Welcome back to another episode of EDPS Talk, where together with our guests, we explore their unique perspectives on data protection and privacy and how they shape their respective fields. So today we have the honor to have Max Schrems with us. I think it's not necessary to introduce Max Schrems for privacy enthusiasts. He has been here with us on a daily life for the last decade. But for listeners who have never heard of him, Max Schrems is almost among the most influential privacy activists and lawyers. He became known for campaigns against privacy violation, advocating for stronger enforcement of data protection and privacy against big tech companies. So Max Schrems is also very well known at the Court of Justice of the European Union. He has not only one but two judgments featuring his name. Court judgment that invalidated the EU-US framework for personal data transfers. He's also the founder of the NGO Nyob, None of Your Business, which is based in Vienna, and working to enforce data protection law, in particular the GDPR and the ePrivacy Directive. So we are thrilled to have you here with us, Mas. Thank you for joining us today, and welcome to EDPS Talk.
Hello there.
So we usually start the interview with a personal question. What does privacy mean to you?
I think privacy means to me that I have some power over information that is circulating about me. So not necessarily that everything has to be hidden or put away, but also that I can, for example, fully share something if I want to. I think the big difference is that you have agency over that to a large extent, not in all cases, but to a large extent. I think that is what I would call privacy in that sense, to kind of decide to maybe overshare sometimes or not, but still be an agency of that.
Thank you very much. The latest reform of the data protection framework, and in particular the GDPR, aimed at introducing a new system of rules in order to ensure a high level of enforcement. So it put stronger accountability obligations on controllers. It gave new corrective powers to regulators, but it also gave individuals new tools to contribute to achieving this goal. And by that, I mean not only new rights, but also new tools to fight for their rights. So as one of the most active contributors to bringing to life a culture of enforcement of data protection rules, how do you see that playing out? Is it only about pushing regulators to do their job, knowing that they face a cruel lack of resources?
There was a lot in your question. So I think what's really interesting is with the GDPR, I mean, it's now 8 years since it was passed. It was passed 2016, then 2 years, we all had a lot of time to prepare and no one prepared. And then basically since 2018, we actually have it there. And in these 8 years, what we see is that the European legislator has put forward this, strong enforcement, serious fines, all that kind of stuff. So we legislated enforcement. But I think what's still missing is to kind of develop that enforcement culture in a lot of the authorities. It depends on the authorities. Some of them actually do quite an interesting job. Others, to be honest, we see almost no activity whatsoever. And if there is activity, it's oftentimes a question of efficiency as well. You mentioned the question of resources. Some of them are really under-resourced. But overall, we also put about 300 million euros into the authorities in Europe. So that's not, all too little. And especially if you then do a country comparison, it's interesting to see that oftentimes with the same budget, one authority does a lot of work and the other one doesn't create all that much output. And I think what's really interesting is how we can get towards that culture of seeing that as a fundamental right and the right that actually needs enforcement. I think we're still seeing a lot of this soft law approach, in a sense, it would be nice if you'd follow, but if not, we're just going to send you an email and say don't do it, which is interesting because for citizens that talk to us, then they're oftentimes feeling, if I park in the wrong spot or if I speed, I get a ticket right away. There is no, email or information that you shouldn't speed another time or so. But if you're a big tech company or even an average company, there is very little consequences if there is breaches of the law. And I think that let's say, this non-enforcement culture, we also see now play out at legal conferences. So I speak a lot at like industry conferences as well. And you see how more and more lawyers openly now, it used to be that they say that in break, but now we are at a level where that's really openly on stage, where they say, if you don't comply with the GDPR, nothing is going to happen anyways. There is a 99% likeliness that there is no consequence. And I think that is something where we have to change and shift the culture and shift gears to a certain extent, because it was maybe understanding at the very beginning that are understandable at the very beginning that there was like, we need to inform people and so on. But now it's 8 years in. I think everybody was informed about the existence of the GDPR. And at that point, I think we really have to see how enforcement works. And we don't really get these answers in the privacy bubble, I think. I think we have to look at how the tax authorities do that, how the building authorities do that, how banking regulators do that, how all these other regulators are actually moving stuff forward. And I think what may be interesting there is we did a study with 1,000 data protection officers, so the people within the companies that are in charge of this, and ask them what would get your boss to actually, be compliant, to, give the resources to really comply with the law. And there were two main answers. The first main answer was penalties, just cost. The second big answer was the reputational harm. So, for example, publishing the decisions is something that would be quite interesting. And some regulators, like, for example, the German regulators, do not publish any of their decisions. We don't even know what the DPAs decide, while, for example, the Spanish regulator publishes 6 or 7 decisions a day. So you have a very good understanding who got a penalty, where, when, in what situation. The other one that was somehow workable, apparently, is that companies police each other, which the GDPR foresees, that a controller is looking at the processor if they actually comply. So this element of the GDPR seems to work. What is probably not anything that Brussels wants to hear usually, or the EDPB wants to hear, is all the guidelines we're producing are rock bottom. Like, it seems the guidelines are by DPOs mentioned as the thing that has no impact in actual compliance. So it's quite interesting, because we produce more and more guidelines with a lot of effort and resource and a lot of time spent on it. But it seems that a lot of the companies really just don't read them. So I think overall what I want to say is we have to get towards what you could call evidence-based enforcement, like to see what really works, what really doesn't, and move forward with tools that work reasonably well, and that also have some, efficiency gain, therefore. And what we really get to is what you could call this general deterrence. So if there's often enough a penalty that is high enough, then usually people start to comply. A good example that was done nicely was the French CNIL, for example. We did a project on cookie banners and researched cookie banners and had statistics on how compliant they are. And the CNIL said there is a certain deadline, and by that deadline, there is the following points that we want you to have in your cookie banner done. And we really saw exactly in that week where this deadline was announced that suddenly all the French cookie banners started to comply. So there is, without even doing enforcement, they then did 20 cases or something, but without doing major enforcement with thousands of websites, you can actually get them to comply if you set a deadline, if there is a probable situation of actual enforcement. So we see that these things do work, and I think that's where some of the answers lie, also in the resource question of, putting your resources actually to use. Very long answer, but that was also a very long question.
No, thank you very much. I hear less prevention and more enforcement. That's what I get from your...
Yeah, smarter enforcement. I think the really big question is smart enforcement, in the sense of how do companies think about this? And we know that especially the Silicon Valley thinks, if I just pay 1 or 2% per year as a privacy tax, I'll just continue doing it anyways. While if there is actual consequences, then the thinking may shift to a certain extent. It's unfortunate you would want to have people comply with the law automatically, but we're in a business also that has this idea of, there's this headlines of move fast and break things, and the big part that's broken is the law, as I usually say. And that is just a mindset on the other side that we just also have to realize happens.
Yeah, thank you. This will bring me actually to my next question a bit, and about maybe the role of the judiciary in this enforcement system. I'm thinking that the European Union is opening the way to collective redress mechanisms. And I wanted to have your view on this new possibility for individuals to bring cases directly before the courts, and especially knowing that it comes from civil law. How do you see this work in the field of data protection? Because this is maybe also one difference with all the field of the law that you refer to also in your first reply, referring to tax authorities. Right? That the data protection is a fundamental right. We have a GDPR aiming at protecting a fundamental right. So the goal is to restore breaches of the regulation rather than compensating for harms. So how would you see the collective redress mechanism working in the field of data protection?
Yeah, we very much get prepared for that. We also get accredited as a qualified entity, so we can bring these cases, which is a longer process. So not anybody can bring these cases in Europe. And I would see it the following way. It's a bit like if you take food hygiene or building safety, you have authorities that are in charge of that. But if a building collapses, then you still have damages thereafter that you can go for. Ideally, we would have authorities that make sure that buildings do not collapse on a regular basis, so there is no need for any kind of damages or civil litigation thereafter. That's in privacy not the reality right now. We still have, if you look at any other website, you have thousands of violations. So we are in this field of actually having to look at what happened thereafter as well. Again, that's not something I like, because we're basically going into a very litigious approach of just fighting each other in court, instead of doing it the right way from the get-go. So it's kind of like, as you mentioned, cleaning up of the problems that have occurred, and ideally we wouldn't have the problems. That being said, right now there is just almost no consequence. So one of the big consequences could be class actions, and all of that comes down to economics. In most jurisdictions, it costs you about 5,000 to 20,000 euros to bring a privacy case, just a deletion, something like that, in legal costs and lawyers' costs and expert costs, court costs, etc. Also, if you go, for example, against a inactive authority, like theoretically you have a free right to complain, but in most jurisdictions, to enforce that through the courts, if the DPA doesn't take the complaint or doesn't deal with the complaint or not investigate it properly, that oftentimes costs you a couple of €1,000 that you don't get back, even if you win, because it's administrative procedure. So on paper, you have a free right, but in reality, costs become a factor. And no one usually brings up 10,000 euros for a deletion request or for an access request that wasn't answered. So in all of these cases, just like in other consumer cases, if your claim is very small, but the enforcement cost is very high, it's economically not feasible to enforce anything. In German, there is a word for that, it's Streuschaden, so a damage that just spreads out to so many people that there is a damage of millions of euros, but everybody individually just has a damage of 100 or 200 or whatever, and that's too little to actually bring a case, because economically it's not feasible. And collective redress can solve that. It can basically make sure that people can group together, and thereby the costs really go down per person, so you end up with like costs of a couple of euros for enforcing a case per person. And that can open up the options to enforcement through the courts. Now, a couple of things there. First of all, if that becomes a bigger thing, then the regulators to a certain extent will lose their role, because if the regulators don't do anything and then the litigation goes into the courts, then the courts will decide about privacy and not the privacy regulator anymore, the data protection regulator. Second thing is also the courts are usually not overly happy about getting these cases. So in our experience, the average judge is like, oh my God, GDPR, I've never heard about this law. I've not had it in law school, so I don't know what to do. And then there's computers and facts that I've never heard of. And, can you just please get rid of this case somehow? So we do expect that also the courts are not overly happy about getting any of these GDPR cases. Just like we have it now on appeal in administrative courts. If you go from the DPA to administrative court, the average judge is just happy to get rid of a privacy case somehow. So we'll see that play out as well. That all being said, if you have 1 million people's data that was illegally processed, for example, and you potentially have a damages claim or an unjust enrichment claim, so the profits that were made from that, you end up with cases of hundreds of millions of euros. And that can really change a lot of this dynamic, because the first cases we looked at so far would basically mean that the company that violated these rules, that oftentimes just has 100 employees, 20 employees, would basically be bankrupt over just one case. like it's literally the case, they make profits of, let's say, 5 million euros, but the privacy case that you realistically have is 500 million. So simply the other side is bankrupt tomorrow if you bring that case. So that's actually a situation that is quite interesting, but also challenging, because, for example, if you bankrupt the other side, you in the end make no money, and you have to pay all the legal costs because the opponent that has to pay all these legal costs is gone. So a lot of that is quite interesting, because some industry sectors, which I would say are the industry sectors that just ignored the GDPR because they would have to stop the whole operation, like typically data brokers, for example, that just under the GDPR have no real existence. They just moved on and did it anyways, hoping that nothing is going to happen. For these types of businesses, that may actually be the end of this discussion. So that could be an interesting tool. All that being said, very complex in detail. You have all the procedural problems of administrative procedure. You don't have investigative powers, which the DPAs have. So if you don't have the facts ready, it's going to be very hard to establish the facts and so on. So all of that is a tricky situation, but also quite an interesting one. In my ideal world, we wouldn't need it because the regulator would do the job beforehand. But now, where that's oftentimes not done, we end up in the civil courts, then I would say. And last but not least, because it came in a year ago, it takes a bit to kind of really get established and get all these approvals and so on. So we would expect the first cases to kind of start next year, realistically. But it's going to be slowly catching up, this whole approach.
Okay, looking forward. I'm not too worried. I think regulators and court could work in parallel and bring different input to the enforcement culture. I don't think court will replace regulators, or regulators I think are doing the best they can. I can assure you about that, and we'd like to do more, but maybe that could be complementary, and this could reinforce both actions. I think that's more as a systemic approach.
And that's also on the European level going to be super interesting, because we don't really have cooperation mechanisms on the European level between regulators, civil courts. We don't have much cooperation mechanism between administrative and civil courts in many jurisdictions. So that's also going to be interesting, because in the end, all of them can refer to the Court of Justice. But other than that, you will have very different paths in different jurisdictions of views on the same legal question. And that, again, is like a call to regulators to be ahead of that, have guidelines on the European level, have consistent enforcement, because the average civil court will follow that. They won't kind of come up with a totally new idea. But if that's not present, then there's a vacuum that these judges will have to fill.
Okay, so now let's turn to AI.
Now we've covered all the easy questions. Let's move to AI.
Yeah, indeed. Let's go into something simpler. So everybody have their eyes on AI. So how could we avoid asking you a question on AI? We are all very well aware of the risks that AI poses to privacy and data protection. We all work very hard to find ways to reduce its impact, to preserve the free exercise of our fundamental rights as well in the world ruled by AI. But for the purpose of this interview, because we intend with this series of talks to delve a bit deeper into the understanding of the interplays between technology, policy, and other areas, and the role that privacy and data protection plays in our society, I'd like to revert the question: do you think that AI can do something for privacy or even for data protection?
Yeah, absolutely. I think, so first of all, what's important for us is to kind of, apply the law reasonably in all of this. And as with any new technology, it has a lot of opportunities and a lot of good things, but that can also, it has all the problems we know as well. And I think what's also important, a lot of the problems will change. We still have the first generation of a lot of that. So some of the crazy hallucinations we see may be better in 2-3 years, and then some of these problems may also change over time. It was interesting because there was recently a stakeholder event on AI, and was just talked about, there could be privacy preserving technologies to make AI possible. But for example, hardly anybody brought up, for example, you can clean data that you use for training using AI. You can basically use the one AI to clean the data that you train the next AI with, for example. And I think there are options like that to kind of really make stuff possible. We are ourselves also experimenting with AI to kind of use that for enforcement, for example. So there is a lot of opportunities in all directions. I think what's really important is to not overestimate what it can do also currently. So we see a lot of like overselling, or I just heard today the word AI washing, like everything that is, basically totally normal processing is now put AI on top because there is a tiny AI element and you try to sell it that way. So I think we have to be reasonable what's doable and what works and what doesn't work. And that will all pan out a bit. What I'm a bit worried about is the like total fear on the one end to say anything AI is always bad, but also the total like, oh, anything AI must be made possible, whatever. Because I'm now old enough to have been part of the GDPR negotiations in Brussels when they happened back then. And a big part was that the law has foreseen that. We called it back then big data and correlations and analytics. But that's basically a description of what AI does today. And a more, let's say, messy approach to data processing, where it's not like your name is in the field and now it's here, but more of a probabilistic processing operation. And that was foreseen, and rights, for example, like the right to correction, is exactly there to cope with that situation, because you may want to correct that, this messy processing operation has a bad outcome that is just incorrect. And that's quite interesting that now a lot of people argue, this is a new technology, so all the law that we have shouldn't exist anymore, like, for example, a right to rectification, even though exactly here we need it more than ever before. So that's, for me, quite interesting how the narrative has recently really changed in not really following a lot of that.
Thank you. Building, maybe following on that, I think AI pushes us to think about fundamental right not in isolation, but more in a systemic way. I can see that in the concept of fundamental right impact assessment in the AI Act. And if we see data protection as a gateway for the protection of all the fundamental rights, how do you see the role of data protection in the system of rights? And do you think that, as some voices have claimed, data protection will become irrelevant?
I don't think it will become irrelevant, really. So the right to privacy is something that there's partly logical reasons for that, which is this horizontal thing you just mentioned. People vote differently in a private voting booth than in public. They speak differently in private than on a stage. So people have reasons for that. And if I don't know, that your boss absolutely needs you, you can absolutely negotiate a different price tag for your salary, while if that person has 5 other people and would love to replace you anyways, you may rather shut up. And just having that information or not really changes your life. There's parts of privacy that are not understandable. So there is this, what you mentioned, this horizontal thing where like privacy can be an enabler for freedom of speech, can be an enabler for democracy, and can, for example, limit, hyper-personalized meddling with democratic processes, talking about Cambridge Analytica and so on. So there's this part, but there's also a part where privacy is not rational. A lot of the things that we feel are private for irrational reasons. So, for example, one of my favorite statistics I read a while ago was that men, on average, I think, can pee within 5 seconds if they go to a toilet, but if another person is in a room, it takes 10 seconds. There's no logical reason for that. It's just a way that we interact. Our typical example is sexuality, love, relationships that a lot of people feel are very private, without any logical reason why it's private. It could be super public as well. And I think there is a reason for that somehow in our DNA, in our culture, in our thinking. And that will never go away. So I think for a long time, this is just going to be here to stay. It is, however, culturally a bit different in where you are. Different things are seen as private and not private, depending on, even within Europe, the geography you're in, or the culture you're in. So I think on that, I think this is gonna have its place, is gonna stay, but will also develop over time. Like, people suddenly realize that something is private because you can suddenly do something with it that previously they may not have felt as private. And the other way around, there may be things that just everybody knows about each other by now, so they don't feel it's that private anymore. But I think the law can actually work with that quite well.
Okay, thank you very much. So last but not least, how do you envisage the way we interact in online communities to evolve in the next 20 years in democratic countries, and what will be the future of our society?
Very simple question, just a little one to the end. To be honest, I don't really know. A lot of that is so fluid and changes so quickly. I think we're really at a time in history where we really have to think how a lot of this interaction changes our society to the good and the bad. If we look at extremism in all directions, a lot of that is fueled by algorithms that are fueled by personal data. So there is a lot of this interconnection. I think, especially as the European Union, we have a bit of a unique chance to kind of look into that more because the US is just de facto not able to pass laws anymore in that direction, like just politically unable. Then we have a lot of the autocracies in the rest of the world that are going to do whatever they want to do anyways. So to have a reasonable approach to that, I think Europe is probably the place to start that and to have a realistic weight on the world as well to actually move it. And I think we need to be a bit bolder in this. I sometimes compare, for example, if we talk about algorithms that meddle with our views on stuff. We have very typical laws, for example, in TV licensing to say you must have neutral news if you want to have a TV license. You must have, somehow of a structure to kind of not be totally crazy in what you do. We limit the minutes of advertisement in TV news and in radio news. So you cannot have more than 10% of your airtime be advertisement. Now, I think a lot of that we could really transplant to a lot of the platforms and say, if you have a news feed, we require that there is going to be some news in it and not just crazy shit. And if you have, if it's advertisement based, fine, but you can't do anything you want to do, and you can't have 50-60% of the newsfeed only be advertisement. So we did that in other areas, and it's still very interesting to me that a lot of that, and maybe in Austria you still have to study Roman law from 2,000 years ago, but you oftentimes realize that a lot of these basic principles were true 2,000 years ago and are still true today. And so I'm sometimes wondering how once it's digital and once it's an algorithm, there's this hands-off mentality of, we don't really know what it is, and when oftentimes a lot of the dynamics are not new and are known and we've regulated in other areas. Doesn't mean that any regulation we did before was the perfect one. But I think we're also, we have to move forward to not just worry about doing too much. If some regulation goes too much, we can always, turn it back. If our democracy goes to shit because people just go ballistic over fake news, that's harder to turn back into the bottle. So I think sometimes we have to be a bit bolder with that, and also have a more holistic and approach to a lot of that. Best example is the discussion about online advertisement, where there's this constant fear of, the news business is going to go bust over that. The news business is going to go bust over that anyways. They're just fundamentally not fundable right now, even if they have a couple of extra cookies, and all the online advertisement revenue gradually goes out of the news media and just goes to everybody else. But that is a blockade why we cannot, overcome the cookie banner discussion, the ePrivacy discussion, a lot of that. And I think we have to sometimes be a bit bolder and say, okay, there are certain things we'll just not allow. And it's going to be okay, and money's going to redistribute somehow else, because, for example, advertisement is not going to go away. It's still going to be there, but maybe not as invasive as it is right now. And I think on that scale, Europe has a position that is quite interesting, that we sometimes have to probably play a bit more with a bolder vision of where do we want to get to, what we want, and what are the tools that we need to get there. Right now, I think we still have a little bit we don't have enough of this vision right now, or this plan. We're more like meandering and change something here and there, and try to be diplomatic and somewhere in the middle ground. And that may not be enough for the time being. I'm worried. If it's enough, I'm happy, but I'm a bit worried it's not.
So more enforcement again, right? Of
More
what we want and what we have decided.
But also clear laws. So I think this one problem we have in EU lawmaking is that it's still a very diplomatic way of lawmaking. It's not like we have a commission that really is full of experts that comes up with a good text. We have a very diplomatic way of negotiating law, and that does not always yield the best results. Best example is we talk, for example, about a risk-based approach. where just any company can just itself declare, oh, well, I think it's not risky what I'm doing. and that is then also for a regulator very hard to enforce if we have these very vague and unspecified definitions. And a GDPR is not too bad in general. Like in general, most of the text makes sense, but there are parts where during the negotiations there was just no agreement, so it was just struck out, and now the regulator sits here with no answer of the problem in the law. And also, even if they do an enforcement, then someone is going to strike it down saying, oh, the law doesn't say that. So I think we need to improve the quality of a lot of that decision making. Also maybe come up with different tools, like a lot of these things in national jurisdictions. If you look at the big changes we had, the National Civil Code was usually done by a commission that really sat down for 2 or 3 years and figured it out, of real deep dive experts and not politicians. And then politics at the beginning said that's the direction we want to go. In the end, had to approve it, obviously. But the really the proper framing and so on was usually done by some brainiacs that really sat down 1 or 2 years and figured it out. And I think that may be an approach that in some elements may be more useful than what we do currently, knowing that that's a mind-blowing idea for how it's done usually. But if you hear about like late nights where just one part of the legislator removes a part of the other one, and then everybody removes 5 bits, and then we agree, but there is now 6 holes in it, then you wonder sometimes if that is how we'll be able to move forward. That all being said, if you compare it to any US law, you're usually still very happy with what you have in Europe of preciseness and clearness, and compared to like what we see in other jurisdictions.
Yeah, more red line maybe in the legislation. Okay, thank you very much. So that brings us to the end of today's episode. We have discussed various points, data protection topics. I like very much how you describe privacy as giving agency, actually, to individual. I think that's very important and what we are fighting for. We discussed the importance of enforcement, maybe different kind of enforcement, to have more also impactful enforcement, enforcement with more impact through different enforcement strategies. We also discussed the role of data protection in the context of AI, and it's important ensuring a free exercise of other fundamental rights. Max, it was an honor having you today. Thank you very much for accepting to participate to this series of talks.
Wonderful. See you then. Bye.
Bye. And for our audience, we're happy to bring you a fresh perspective on privacy and data protection from a variety of fields. If you enjoyed this episode, so don't forget to catch up on previous interviews with Frances Hogan or Dr. Musilova from NASA, or to follow the EDPS on our channels to discover about our projects marking the 20th anniversary of the European Data Protection Supervisor. I am Fanny Couder, and this was the EDPS talk with Mike Schrems, privacy lawyer and founder of Nyob. See you in next talk.